Hi, my name is David Fraser. I'm an internet technology and privacy lawyer with the law firm McGuinness Cooper in Halifax, Canada. Today I'm going to talk about how Canadian privacy laws can apply to companies that are not at all based in Canada. So I'll start off with my usual disclaimer. This is intended to be educational, hopefully informative, with an intended audience of lawyers who would be familiar with the concepts of jurisdiction, conflicts of laws, and things like that. This is a complicated area of the law, and many of the general rules have exceptions. So obviously, if you're dealing with a particular situation and want to know the lay of the land, you should be talking to a qualified lawyer. The opinions that I express in this video are mine and mine alone and shouldn't be attributed to my firm or its clients. And of course, I'm talking about Canadian law and Canadian privacy law, so all of this is limited to Canada, and certainly conflicts of laws is one area where different countries' laws can vary significantly. So what am I going to cover here? I'm going to talk about what Canadian laws exist that most foreign companies would need to be concerned about if they're doing business, principally virtually, online with Canadians. I'm going to talk about how the law of Canadian jurisdiction works, at least insofar as it applies in these sorts of circumstances. I'm going to talk about a couple cases that have some important lessons about cross-border privacy regulation in Canada. The first one is called Lawson and Accusearch from some time ago. The second one is called AT and Globe 24H. And then I'm going to talk about an interesting joint investigation between our federal and British Columbia privacy commissioners into AggregatelQ. And then I'm going to provide a bit of a wrap-up. So what Canadian privacy laws are we talking about? So we have federal privacy laws in Canada, or we have one main commercial privacy law in Canada federally. And we have three provinces, British Columbia, Alberta, and Quebec, that have their own provincial privacy laws. So our federal privacy law applies to all collection, use, and disclosure of personal information by what are called federal works undertakings or businesses. So those are companies that are, and organizations that are federally regulated. So those would be, for example, chartered banks. They would be railway companies, transportation companies, telecommunication companies, and companies like that. PIPEDA also applies to the collection, use, and disclosure of personal information in the course of commercial activity by all organizations other than those that are provincially regulated in the provinces of British Columbia, Alberta, and Quebec. And it's also said, or at least our commissioner has taken the view, that PIPEDA will always apply to cross-border transfers of personal information, whether that's from outside of Canada into Canada, or whether it's among or between our different provinces in Canada. So if you're an international business doing business with consumers in Canada, you're going to have to worry about the federal privacy law and the laws of British Columbia, Alberta, and Quebec. And a lot of the same principles are going to be applicable depending upon where the individual consumer resides. So the law of Canadian jurisdiction really boils down to a phrase, real and substantial connection. So if there is a real and substantial connection between the activity at issue and the jurisdiction at issue, then Canadian laws can apply, or at least a regulator or a court can take or assume jurisdiction in those circumstances. So it's a real and substantial connection. So it's not something that's fleeting or something that's trivial. But I think also in the background we need to consider what is the nature of privacy law. Privacy law is very similar to consumer protection laws. So they are put in place by a government in order to protect the rights of their consumers. So I think it's reasonable to assume that among the factors to be considered is that Canadian privacy law was put in place by the Canadian Parliament in order to protect Canadian consumers. And so dealing with the data of a Canadian consumer is likely enough to trigger the real and substantial connection. Now we have a good illustration of that. This is one of the earlier cases under our Federal Personal Information Protection and Electronic Documents Act that went to the federal court. So this is called Lawson and Accusearch, and I'll include a link to the case in the description below. And what we had here was a US-based background check company. And so they were entirely domiciled in the United States, did not have an office in Canada, did not have a presence in Canada. But what they did was that they sold background reports on, not surprisingly, residents of the United States, but also residents of Canada. So we had a consumer activist in Canada, still do, named Philippa Lawson, who went on the website and acquired her own report. And it was produced. She took a look at it, she disagreed with it, and then she complained to the Federal Privacy Commissioner that this report included information that had obviously been collected about her without her consent. The Privacy Commissioner commenced an investigation, tried to reach out to the company in the United States. The company in the United States proved to be not at all cooperative with the investigation. And because the Commissioner's office could not continue its investigation in any sort of meaningful way, they closed their file and advised Philippa Lawson that they did not have jurisdiction to investigate a company entirely based outside of Canada. Ms. Lawson disagreed, and so she went to the federal court, doing something called a judicial review related to the decision made by the commissioner or the commissioner's office that they did not have jurisdiction. And the federal court concluded at the end of the day, and I'll talk about some of the details of their analysis in a moment, that the lack of effect or lack of ability to investigate does not affect whether or not they had jurisdiction in the first place. So the court did some interesting and useful analysis and essentially said that, yeah, the starting point is there never was an intention on the part of our federal parliament for PIPEDA to regulate globally all collection, use, and disclosure of personal information, regardless of where the individual is resident or regardless of where the company is resident. But when you do a regulatory investigation, there has to be some sort of a connection, perhaps a real and substantial connection, to the jurisdiction that's carrying out the investigation. The court said, however, I believe the Privacy Commissioner erred in law by taking the position that Ms. Lawson's complaint could only be investigated if Parliament had intended and had given extraterritorial effect to PIPEDA. The court essentially said that isn't what is required. They don't have to have the ability to assume jurisdiction over subject matter outside of Canada because they had jurisdiction over subject matter within Canada, which was the collection of Ms. Lawson's personal information. The court said there's a difference between whether or not the Privacy Commissioner can effectively investigate and whether the Privacy Commissioner is empowered under Canadian law to investigate. At paragraph 39, the court says, the fact that an investigation might be ineffective is not the point. While it is true, as the Commissioner says, that her office has no extraterritorial subpoena power over a non-resident, neither does a court of law. So the Commissioner does, in the course of an investigation, have the ability, for example, to subpoena records, to summon witnesses and things like that. That power ends absolutely at the border. That may thwart an investigation. That may make it impossible to do a meaningful investigation. But at the end of the day, that doesn't mean that the Commissioner didn't have jurisdiction in the first place. The court also noted that effectively this decision by the Privacy Commissioner cuts off remedies that Ms. Lawson might have. So for example, under PIPEDA, an individual who's a complainant can go to court and the court can order damages and the court can issue other forms of orders. But under PIPEDA, you can only get to court if you have a final report from the Privacy Commissioner of Canada. If the Privacy Commissioner has said, I don't have jurisdiction and has refused to issue that report or even do a cursory investigation, then the individual is denied that ability. And court judgments can in fact be enforced outside of Canada under international convention. The court also said importantly, and this is also about the real and substantial connection, and dealing with conflicts of laws questions in an international and internet-enabled sort of environment, the court noted, we're dealing about the collection of personal information. And when you're dealing with the collection of personal information that takes place via telecommunications, that collection takes place both here and there. It takes place, in this case, in Canada. That's where the information started. But it was collected by the organization, in this case, that was in the United States. And so the fact that where their servers were, the location of their website, things like that, that's not relevant. There was a collection of personal information about a Canadian that took place in Canada, and that's enough of a real and substantial connection to make that operative. The next case I'm going to talk about is one called AT and Globe 24H. And this is an interesting decision. It's problematic in a bunch of ways, but I don't think the jurisdictional analysis in this case was incorrect. So here you had a Romanian company. I'm not even sure if it was an incorporated company. You had an individual who operated a website, and he was based in Romania. And what he did was he set up a bot that went around and scraped content off of Canadian websites, principally from Canadian courts and tribunals. And in Canada, most courts and tribunals and websites that report on the decisions of courts and tribunals don't allow themselves to be indexed on the public internet in order to protect the privacy of individuals whose information is mentioned in those decisions. So what this guy did was he scraped all that information, he republished it on his own website, with the intention that you could pay in order to get a decision taken down if it was causing embarrassment or anxiety or anything else like that. So it's pretty well an extortion website. And the Privacy Commissioner's Office received a number of complaints, one of which was from an individual who is identified by a pseudonym as AT. And the Privacy Commissioner concluded that Globe 24H had violated Canadian privacy law. The company had cooperated to a certain degree in connection with the investigation, but it didn't sound like they did fully. And at the same time, as I understand it, the Romanian Data Protection Authority was also carrying out an investigation and did find some culpability on the part of the individual and the organization behind the website. So at the conclusion of the investigation, after receiving a finding that his complaint was well-founded, AT went to the federal court, and the Privacy Commissioner went along with AT. The respondent, the website, and the guy behind it did not show up, so it was largely uncontested. The only information and evidence and argument in front of the court was that which was provided by the Privacy Commissioner and the complainant. Now, the Privacy Commissioner's file that was put in front of the court did include some of the correspondence with AggregatelQ. And what the federal court found was that there was sufficient jurisdiction in order for them to issue an order. So the court specifically said, using the real and substantial language requirement, as Mr. Radulescu and Globe 24H are foreign-based, the court must consider whether there is a real and substantial connection between them and Canada to find that PIPEDA applies to their activities. The operative question underlying the test is whether there is sufficient connection between this country and the activity in question for Canada to apply its law consistent with the principles of order and fairness, and of course, international comity. So in this case, the court then says at paragraph 53, the court has applied PIPEDA to a foreign-based organization where there was evidence of sufficient connection between the organization's activities and Canada. The relevant connecting factors include the location of the target audience of the website. So are they targeting individuals in that jurisdiction? The source of the content of the website, so in this case, Canada. The location of the website operator, in this case, Romania, and the location of the host server, which I'm not sure why that's even really a consideration at the end of the day, because servers can be hosted pretty well anywhere or in multiple places, depending on how you set things up. So the court said in this case, the location of the website operator and host server is in Romania. However, the organization's activities take place exclusively through a website. The physical location of the website operator or host server is not determinative because telecommunications take place both here and there. So the same sort of sentence that was used and the same sort of terminology that was used in the Lawson and Accusearch decision. And so in that case, the court found that there was a real and substantial connection, so the Canadian privacy law could apply, and therefore the federal court had jurisdiction to issue an order, which they ultimately did. Now, one final case to look at is a case of AggregatelQ. Now, this one did not go to the federal court. I wish it had. It would be interesting to see what the analysis would be at the end of the day. In AggregatelQ, you're dealing with a company that's based in British Columbia, and they were a contractor that was involved in analyzing information on behalf of political campaigns. They came to the attention of regulators around the world in connection with the Cambridge Analytica scandal, I guess for want of a better term. And so the Privacy Commissioner of Canada and the Information and Privacy Commissioner of British Columbia carried out a joint investigation of AggregatelQ. Now, they were a company based in Canada, but the vast majority of their clients were outside of Canada. And what I found to be most interesting, and most Canadian privacy practitioners who I've spoken to about this decision found it a little bit puzzling that the privacy commissioners of British Columbia and Alberta imposed on AggregatelQ Canadian privacy laws and privacy rules, even though they were acting entirely as a processor of personal information from other places. And so while they were not in a position to determine whether or not, for example, the data that was collected in Europe was done so in compliance with the GDPR, they did impose on AggregatelQ the obligation that they can only process the information as though it is subject to Canadian privacy laws. So here's what from the joint finding of the Federal and British Columbia Commissioners. So they start by saying that AggregatelQ would be responsible for complying with the consent obligations that might arise under privacy legislation. And then they deal with the fact that AggregatelQ doesn't have a direct relationship with anybody who is related to that personal information. It's entirely up to their clients, who would be customer-facing or individual-facing, to make sure that adequate consent was received for all subsequent use and/or disclosure of that personal information. There's no discussion whatsoever of the fact that in a large number of cases, privacy laws permitted the collection, use, and disclosure of that personal information by those organizations. But they're saying essentially that once it's in the hands of AggregatelQ, AggregatelQ needs to bring it up to Canadian standards, regardless of whether or not where the information came from, and whether its use is entirely consistent with or lawful when looked through the lens of the laws that would actually relate to the protection of those individuals. So one example that I have, AggregatelQ was involved in an election campaign in Newfoundland and Labrador, if I recall correctly. There are no privacy laws that regulate the collection, use, and disclosure of personal information by an election campaign in that province. And so it could be collected, used, or disclosed in that province without consent. But as soon as they hand it over to a contractor, this decision or this finding would have you believe that all of a sudden consent is required, which really flies in the face of what many of us think about when it comes to controller-processor relationships and also agency relationships, where if somebody deals with information as an agent of a principal, the obligations of that principal should apply to that information because the agent is not collecting, using, or disclosing it for their own purposes. So the commissioners say this is at paragraph 70. In the circumstances, we would have expected AggregatelQ to have ensured that there was adequate consent for its collection, use, and disclosure of personal information on behalf of SCL, one of their clients. The fact that it did not do so is particularly concerning since certain information used to target individuals would have been sensitive, which would generally require express consent. Well, only if it's subject to Canadian legislation. They then say at paragraph 71, to be clear, we're not finding in this section or below that AggregatelQ's foreign clients were required to comply with Canadian and BC privacy laws. The practices of those political organizations would generally fall outside of the scope of PIPA, that's the BC law, and PIPEDA, and in any event, we're not the subject of this investigation. Yeah, that makes perfect sense. But, they then say, to the extent that AggregatelQ wished to rely on the consent obtained by those foreign clients for its own collection, use, or disclosure of personal information on their behalf, it would need to ensure that such consent was sufficient under Canadian or BC law, as the case may be, for its own purposes. But they also then say in this finding that AggregatelQ never used that information for their own purposes, but only for the purposes of their client. So this is a problematic result that seems to suggest that Canadian privacy law is going to apply to a foreign company when they're collecting, using, or disclosing personal information of Canadians. That makes sense. That's consistent with the way things usually work. But then it seems to impose an obligation that Canadian privacy law to personal information that originates someplace else, where that information might have not been protected by any privacy laws. It might have been the express intention of the legislature of that jurisdiction, but still we're going to double layer on Canadian privacy laws for Canadian contractors. And again, it doesn't make a huge amount of sense. So what does all this mean? So at the end of the day, if you're a company or an organization outside of Canada and you target Canadian consumers, that's probably enough for Canadian regulatory jurisdiction to apply. Now, whether or not a Canadian regulator can effectively investigate you, and whether or not, for example, they can compel you to produce records or to produce testimony and things like that, is really going to depend upon where you are and what sort of cooperation they might be able to get from your local regulator. Because one of the things that I have also found is that where a Canadian investigation of a foreign entity is commenced by a Canadian regulator, one of the first things that regulator does is they pick up the phone and they call the local regulator, either to get them on board for a joint investigation or just to bring this to their attention. So the fact that Canadian investigative jurisdiction doesn't extend outside of Canada I think provides little comfort at the end of the day for a large number of organizations. And also, if you're large enough or you're concerned about your reputation, the Privacy Commissioner does have the ability to make public any information about an organization's personal information management programs, et cetera. And so really has a significant ability to name and shame. So I hope this has been educational or informative or useful for non-Canadian lawyers. If you have any comments on the contents of this video, please leave them in the comments below. I'd also love to hear any suggestions for further topics in my YouTube channel. And thanks for watching, thanks for tuning in, and we'll see you next time.